The next jurisdiction that must be looked into to understand the issue as a whole would be the United States. In the United States, in stark contrast to the Indian patent legislation or the United Kingdom patent legislation or the European Patent Convention, there is no negative definition of what is permitted within the realm of patentability. In other words, there is not a single definition of what is not patentable in the United States. As opposed to these three jurisdictions, the United States permits courts to interpret Section 101 and Section 100 of the United States patents legislation to understand and to come out with propositions as to what is fundamentally patentable. And what seems to be guiding the courts of United States is whether or not there is a certain utility in a particular process and a product. Usefulness and a tangible result have been the two guiding pillars or guiding posts of evaluation of patentability of subject matter in the United States, be it in the realm of biotechnology or in the realm of business methods or in the realm of computer programs. The first decision that needs to be looked into in this in the United States is Diamond versus Deere. In Diamond versus Deere, the United States Appeal Court went on to hold that as long as a process or a product is useful and comes out with a tangible result, it must be deemed as patentable, and this decision was delivered in the context of a computer program or software. However, this is a very nebulous decision and does not lend itself to understanding whether or not a process which may be useful in a business context and which does not involve any kind of technical character would also be patentable under the United States patent law. To understand this, one could probably look into the next important decision, that would be State Street versus Signature Financial. In this case, again, the United States Federal Court went on to hold that although anything useful or anything that comes out with a concrete tangible result is patentable under the United States patent law, what is important for the subject matter to establish is a material transformation. In other words, as a consequence of use of the subject matter of the patent application, a material must undergo physical transformation, and this has been used as the test of what amounts to a technical effect or what amounts to technical contribution. This for me is a very crude way of going about it, for the simple reason that not all processes result in the transformation of material from one form to another. If one were to ask oneself if there is at all any transformation that goes on in a mobile phone as far as a material is concerned when a computer program is used to execute a certain function, the answer in 9 out of 10 cases will have to be a no. Consequently, the material transformation test does not seem to be the best way of going about it. The next decision that could be looked into to understand the position is Bilski versus Kapos, which is a decision of the United States Supreme Court itself. Now, in stark contrast to the previous two decisions, the subject matter of this particular decision was not the use of a computer program used to execute a technical function, but the use of a computer program to execute a business method. Despite this, the United States Supreme Court went on to hold that business methods per se are not unpatentable under United States law, and if there is a computer program that executes a business method and there is a useful result, it would still fall within the realm of patentability. Now, if one were to take a step back, it becomes clearer that the position of the United States law appears to be the broadest in terms of what is permitted subject matter and what is prescribed from the scope of patentability. The problem with the decision of the United States Supreme Court is that it practically permits any subject matter which is useful to be included as part of a patent application for the purposes of grant of a patent on that subject matter. This is troublesome because it would not only increase the realm of patentability probably beyond the actual scope that was intended by the United States legislature originally when the Patents Act was introduced through the Constitution, it also ends up adding to the confusion of extreme propertization of commerce. In other words, If practically everything that is useful is capable of being protected by way of a patent, then it renders nugatory other forms of intellectual property such as copyright, and it also ends up lending or granting a strong right such as a patent right on something which is not technical in nature. Patent rights, if one were to view it through the lens of its history or its evolution or its origins, have always been granted on technological subject matter and not merely because something is useful. So tomorrow, if a university were to come out with a manner of conducting its classes which reduces the duration of the class and also ensures that students are best positioned to receive what is being imparted by way of an instruction, this would be equally useful for the university. But does it mean that this falls within the realm of patentability? Is this patentable? This is a question that ought to have been asked. In the realm of commerce, there are several aspects or several processes which could be useful, but not every process deserves or merits the grant of a patent, because patents are not meant to be granted for everything that is useful unless and until there is a technological problem that is being solved through a technological solution, through a technical effect. The most important decision which more or less clarifies the broad scope of US law is the decision of the Federal Circuit in June 2014 in the Alice case, where it was held that anything that rises above the level of a mere abstract idea is capable of being granted a patent. This for me is the broadest possible proposition of the law, which comes closest to militating the jurisprudence of patents and closest to militating the actual idea behind the introduction of patent rights. So on the basis of these three jurisdictions and the case law that has been evolved there, it could be said that the language of section 3K of the Indian Patents Act does not in any way permit the adoption of US law or the interpretation of US law on what is permitted subject matter in the realm of computer programs. We could take support from the interpretation of Article 52 of the European Union and Article 1 of the United Kingdom, and possibly apply principles that have been evolved or formulated in the United Kingdom, because the language of the United Kingdom provision comes closest to us, and the manner in which it has been interpreted also ensures that a certain balance is struck between grant of patents to subject matter involving technical contribution and rejection of subject matter which is not only just a mere abstract idea but is also in the realm of business methods. To summarize what I said, Indian Patents Act, particularly the interpretation of section 3K, has to be interpreted very restrictively for the simple reason that it is a negative definition, and negative definitions are intended to be interpreted restrictively so as to give effect to the actual policy or intent of the legislature. If, for instance, if section 3D of the Patents Act ensures that there is absolutely no room for evergreening in the realm of pharma patents, and that is the rigor with which section 3D has been interpreted by the Indian Supreme Court in the Novartis case. The same kind of rigor must be applied in the interpretation of section 3K so as to ensure that we do not end up going against the actual intention of the legislature in restricting the scope of patentability to subject matter that otherwise attracts computer programs per se. Now in this context, it becomes important to also understand the position of the Indian Patent Office in the manner in which it reviews or examines application that perhaps attracts section 3 or specifically section 3K. Reference may be had or regard may be had to the manual of patent practice and procedure of the Indian Patent Office to understand what goes on inside the patent office and what is their interpretation of section 3K, what kind of guidelines have been issued internally when it comes to review of patent applications that claim computer programs. Although it must be clarified that this manual does not have the force of law, since it is merely a manual, it is merely an internal directive from the controller to his examiners, providing them with a certain clarity or with a certain approach as to how patent applications must be examined. Nevertheless, it also tells us whether or not the first line of defense, that is the Indian Patent Office, has understood the meaning and import of section 3K to give effect to the intent of the legislature. Now, the manual of patent practice goes on to say that mere computer programs or computer programs by themselves cannot be granted patents, and there must be some kind of a system or some kind of a hardware connection or some kind of a technical connection in order for it to be granted a patent. Now, the problem with the language is this: there is a distinction between technical effect, technical contribution, and the need for a hardware, for the simple reason that ultimately, if the hardware has been available in the public domain prior to the filing of the patent application, and all that is being done in the patent application is to combine the computer program with the hardware, then even if the test of patentability were to be applied to this combination, ultimately the new feature in this combination is the computer program. In other words, the test of patentability and the tests of novelty, non-obviousness, and industrial application will have to be applied to the central feature, which is the computer program, and not to the entire system. This is because what cannot be done directly cannot be done indirectly. Therefore, if computer programs per se are not to be granted patents in this country, then the alternative cannot be to apply this particular test to the system when the system otherwise has been in public domain, when the system otherwise is not the subject matter of a patent, merely because there is nothing novel about it, and the only novel feature about it is the computer program itself. Therefore, instead of providing an escapist option, so to speak, it would help to have a much more clearer and pragmatic approach to the definition, which is to say that so long as the computer program is being used in a technical context to achieve a technical solution through a technical effect, then it would fall outside the prohibition of computer programs per se. This is perhaps the best or the most optimal way of doing justice to the language, and also to ensure that not all patent applications are rejected on grounds of section 3K, because that would mean a violation of article 27 which clearly of TRIPS, which clearly goes on to say that member states do not have the option or flexibility of discriminating between technologies. Therefore, computer programs which have a technical effect and which have a technical contribution are at par with other forms of technology or other branches of technology which merit the grant of a patent. Therefore, to summarize, in the absence of judicial guidance on what is a computer program per se, not only can the Indian Patent Office take support from the interpretation of comparative or comparable provisions in the United Kingdom and the European Union, it would also help if the Indian Patent Office were to understand the purpose of introducing the words per se with computer programs. Therefore, as long as one does not claim a patent over the manner in which multiplication is done, or addition or subtraction is done, or any of these rudimentary functions are done which are abstract in nature and which are very fundamental in nature, and there is a technical application to the computer program, it must be deemed as being eligible for the grant of a patent, or at least for examination on other aspects of patentability such as novelty, obviousness, so on and so forth. Finally, to repeat what was said earlier and to reiterate the point emphatically, Section 3 is meant to be a filter to prevent grant of a patent or to prevent examination of patent applications which claim ineligible subject matter. Therefore, it would be wrong for the Indian Patent Office or the Intellectual Property Appellate Board or a court that is seized of the validity of a patent to apply the tests of novelty, obviousness, and industrial application before understanding whether or not the claimed subject matter is eligible within the meaning of Section 3. One hopes that at some point in the future, courts get an opportunity to apply the interpretation or to interpret Section 3K in order for the Patent Office to have greater clarity as to how it must deal with pending patent applications. Thank you.